I'm going to say and I'm going to sing.
Wow.
Let me start with the singing. It was very beautiful the day I presented to have somebody from the King's administration singing just so beautifully. And I wanted to sing in response because I'm leaving this afternoon. 1952, I'm 17. It's exactly 300 years since Jan van Riebeeck landed in Cape Town, put up the flag, and the way we learnt at school, South African history started. So the history of colonization and domination started. It's 300 years, the army are out, the parades in favor of white supremacy are powerful, and there may be 100 of us in a small room, a little bit bigger than this, in a place called Salt River, working class area of Cape Town, and we're launching the Defiance of Unjust Laws campaign. And I'd just joined the struggle then, and the songs used to be sad, sad, sad songs. My boye, my boye, my boye, Africa, come back, come back, come back, Africa. And then it would be Senzenina, 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 Senzenina. What have we done to deserve this? And we would all join in 4-part harmony, just very, very beautiful. And suddenly, volunteers obey the orders, volunteers obey the orders, volunteers obey the orders, be ready for the action now. Dr. Maroka, Dr. Dadu, J.B. Marks, Katani Lepapapi, and they call for volunteers. And I said, take me, take me, take me. My friend said, you can't. I said, why not? He said, because you're white. In any event, some months later, I did take part in the Defiance of Unjust Laws campaign. Some years later, I'm alone in a cell, solitary confinement. Those of us involved in struggle in those days, we read prison literature. We always imagined we'd be locked up. What would it be like? What would it be like? And it was worse, worse, worse than I'd thought. Total isolation, no one to speak to, nothing to do, no activity. Human beings are meant to converse, to interact. If you voluntarily sit on a pole for spiritual reasons, that's a choice you make. It's not something imposed upon you. And I would go through the alphabet, songs, always, because, Charmaine. Anybody wants to know the hit tunes of October 1963, just get that list. And my favorite was Always. And I composed, do you know Always? The Irving Berlin song, I'll be loving you always, with a love that's true always. And I converted it into, I'll be living here always, year after year, always, in this little cell that I know so well. I'll be living swell, always, always. And I'd waltz around and feel moved that this Irving Berlin song, picked up by Noel Coward of upper middle class manners, blithe spirit play in the West End, was keeping the spirit of a young revolutionary alive in Cape Town. I'll be staying in always, keeping up my chin always, not for but an hour, not for but a week, not for 90 days, but always. And I sing the song, if ever there's a judge in the audience, I find a way of telling that story and singing that song, because I just believe that judges should go to Rwanda and judges should sing, not necessarily on the bench, but should be human beings and enjoy expressing their voice. The last song would be the one that I speak about when I'm dealing with the theme of soft vengeance, which is very relevant to today. And getting a note in hospital, I'm lying in bed, don't worry, Comrade Albie, we will avenge you. Avenge me? We're going to cut off the arms, blind in one eye. Is this the country we're fighting for? If we get democracy, if we get equality, if we get the rule of law, if we get freedom, That will be my soft vengeance. Roses and lilies will grow out of my arm. And it became, in a sense, the theme of my life. I'll be going to Colombia in October. I've been invited there. Hopefully we will be celebrating the accord. Hopefully the people of Colombia will support it. People want me to be there to see that there's another way of doing things. Other punishment is not the only way of getting accountability. It's not the only way of respecting the people who suffered, because the people who suffered also have a right to peace, a right to dignity, a right to feel their suffering wasn't for nothing, that a beautiful society or a better society emerged from it. In any event, lying in hospital, mostly I'm feeling very chipper and I'm thinking these deep thoughts until I'd wake up in the morning at about 4 a.m. The painkillers have worn off, I'm completely alone, and I'd feel a bit sorry for myself. And I'd sing a Negro spiritual, which was odd because I'm very secular, and it would be, it's me, O Lord, standing in the need of prayer. It's me, O Lord, standing in the need of prayer. It's not my brother nor my sister, but it's me, O Lord, standing in the need of prayer. Now, if I was doing this in South Africa, the people would all join in. It's me, O Lord, standing in the need of prayer. But unfortunately, lefty academics these days are not very good at vocalizing. So,
give us one more chance.
Well, let's do this one. It's me, O Lord, standing in the need of prayer. It's me, O Lord, standing in the need of prayer. It's not the professor nor the doctor, but it's me, O Lord, standing. But it is a wonderful coincidence that I'm saying this thank you and in effect goodbye. I'll see you lunchtime. I'm giving a lecture at SOAS at 6 o'clock to respond to everything that Stuart was saying, right and wrong. And the most interesting themes are where you are right and wrong at the same time. Of course, I'm going to be more right than wrong, and he was more wrong than right, but that's the way the dialectic goes. But it's wonderful to be sitting on the platform with Ruti. And I think, apart from anything else, the legal community and the academic community owe her big time. You launched an industry, Ruti. If we put up statues, you deserve 10 statues. Now, I've been an iconoclast, so we can put them up and knock them down afterwards. But I still remember in the early 90s it was, meeting this person and couldn't quite work out, Argentine, American, something. Nothing fitted. She wasn't involved in the big libertarian versus communitarian battles and taking a side. She was coming up with her own indeterminate kind of way of doing things, messing up everything. We're looking for clarity. We're looking for determinacy. And particularly when you're fighting a revolutionary struggle, you want to change things and you're doing it for certain values to achieve certain outcomes. And you were muddying it all and messing it all up. The very notion transitional justice sounds like it's a contradiction in terms. It becomes even worse when it's transnational transitional justice. You think there's a misprint in it. But it's been said there's nothing more powerful than an idea whose time has come. And the messenger of that idea was Ruti Teitel. You anticipated, in a sense, that time. The theme has branched out. There are transitional justice institutes and seminars and discussions and books and literature all over the world now. And we really owe Ruti that huge, wonderful, it's wonderful to pay wonderful debts. And it's a wonderful debt that we offer you and that we pay to you. And it's brilliant for me to be at this terrific conference. It's lively, bright. Even if the singing doesn't reach the highest standards, they have to import somebody from admin to do the singing.
The chapel's next door.
Yeah. So Ruti, it's just terrific being up here. I'm going to go and sit down with the masses.
Thank you, Professor Alvisage, for those beautiful words and beautiful singing. It was a very emotional moment. Thank you for that. Now, we have the great opportunity today of having with us Ruti Teitel, who has been one of the most influential academics in the area of transitional justice, as well as in other areas of her expertise. Now, she needs no introduction, and you can go through the endless list of titles and books she has published. But the only one I want to mention today is Globalising Transitional Justice, which has come out in the UK this January. It's a book from last year. You all have the flyer, so you can go through it. And I leave the room, so please join me in welcoming Ruti Teitel.
Muchas gracias, a fellow Argentine. So, and thanks so very much, Albie, for both your comments 2 days ago. I was here on Monday, and it really launched a great week here at King's. And it looks like from the prior panel that we really already got the ball going. So a lot of ambitious questions, both raised by Justice Sachs and by the prior panel. I want to take this moment to really throw out some of my current thinking about globalization and transitional justice, which I sketch out in some greater detail in the book. The book reflects the last 10 years of essays. Some of them are book chapters, some of them are law review articles in kind of obscure journals. Since, some kind of reflections on the field and the direction of the field since my first book came out. And as has already been mentioned, this is really an industry now. It was not necessarily how it was contemplated in the 1990s. When I first got into this, just some brief biographical points since they've been raised. When I first got into thinking about this, it was at the time that Latin America was going through its transitions, and Eastern Europe and South Africa. I see these as connected, clearly part of the detente at the time between post-communist US and the Soviets, and the economic collapse in a number of countries that allowed political events to move forward. I'm originally from Argentina, and so the events that had started in Argentina, the disappearance policies, the response to disappearances, the mothers of the Plaza de Mayo, the rise of Alfonsín, his running for office on the issue of accountability. These really captured my imagination as a young lawyer, and then the rest was thinking about how there was really a non-ideal, these were non-ideal moments. They were political moments of great transformation, but they weren't associated with ideal conditions. There were judiciary often that were held over from prior periods. There was an absence of rule of law in many countries, certainly in Argentina, a problem with the police and with the judiciary. This was alluded to with the prior speaker, the judge from Brazil. These are moments when talking about criminal justice or even civil justice becomes quite problematic. And that's really that problem, that conundrum of how do you reconcile political transformation within that legal context. That's really what animated my thinking. And yes, the term, I identified the term in '91 in a grant application to the United States Institute of Peace when I applied to try to get a year to dialogue with governments in Eastern Europe and actors there, and get my thinking going on transitional justice. So let me just throw out three contexts that could be seen as a framework or 3 different political contexts for this issue of globalizing transitional justice. I'm going to spend most of the short remarks on the last one, on the global context, but let's at least, for purposes of the genealogy, talk about the first 2, because issues of history are very much part of the conversation. And then I really want to have time for questions. So, it's a great group, and many of you come from different countries and different experiences, and I think that having more of an exchange will be great. So just I want to talk about transitional justice post-bellum, the post-World War II period, but also the analogies to post-conflict today. As one context, I'd like to talk about a second context, which is post-negotiated or pacted transitions, constitutional transitions, and South Africa is probably the leading example of this context. And the last one, the globalized or normalized transitional justice and the rise of the era of accountability. So on post-bellum, if we think about post-war Europe and Japan, but also we've seen other post-bellum instances of transitional justice now, or at least a debate about them with respect to recent humanitarian interventions after the end of the Cold War. Now, there's a lot of talk always about Nuremberg, and almost every international criminal law book goes back to that period. But I think that seeing this from a transitional justice lens is different than from an international criminal law lens or from a human rights lens. And very often human rights books also go back to that moment and talk about it as an engendering moment. But the moment actually presents a conflict, a dilemma, and tensions with existing law. And I think this is really what I want to bring out here. The post-bellum law contemplated at the end of war is a law that deals with stasis, preservation of existing claims. The law of occupation doesn't contemplate transformation. And we see a lot of discussion about the expectations of law of occupation today in light of places like Iraq and what was owed in a number of other instances. So what you have is this tension between the claims for democracy building and transformation in Germany and in Japan, and the existing use post-bellum. If you think back to other instances of justice at the end of war, what is at stake is really the assessment of borders and the restoration of the status quo ante. Restoration of the status quo ante. And that entire vision, which is backward-looking, right, and restorative in nature, really is in tension, I want to say, with a transitional justice lens on that period. And I think this hasn't come out strongly enough because we tend to focus on the Nuremberg Trials and the idea of the trial, but it's really about what were the the stated animating goals of the trial that make it different from the existing legal framework at the time. So when the U.S., which took such pride in the Nuremberg Trials, and remember that Churchill, since I'm in the U.K., one can't help but think about Churchill. Churchill said, just line them up, okay? What's the point, all right, of spending a lot of money on a trial? And, or on a series of trials, and the U.S. had what often seemed like grandiloquent, transformative statements about what the purposes of the trials were. But part of what, this works hand in hand with a number of other forward-looking aspects, which is the Marshall Plan, the succeeding trials, the Control Council 10 trials, a variety of different aspects of occupation law that are going on at the time, and attempts to exclude Nazi judges from the judiciary, et cetera, et cetera. So disqualifications, administrative justice, so not just the criminal justice, but administrative justice, et cetera. And of course, today, I don't know if I'm affecting, I'm trying to move so that we need more singing now. We need so that's really the bigger concept there, and I think that we can see that there is a tension, a trade-off between the existing understanding of the way the law of war would work, and you could say rule of law and certain stability associated with that, and the claims made for a forward-looking use of criminal law and this approach to already tinkering with the understandings of occupation law as essentially just preserving the status quo. Now, if you think about Afghanistan and the debates about Afghanistan and Iraq, you can see that these tensions continue to be there, right? The whole question of what is the law of occupation and the critique for moving away from preservation, you know, the concern that this, you know, is imperialism and could result in, you know, in a return to colonialism or empire. That tension was very present at the end of the war, and it's part of what I tried to capture with the word transition, which is that it isn't that, you know, that it's a use of the law and a conception of justice that isn't just restorative in nature, that it wasn't just enough to talk about restoration to the status quo ante, but the concern about what had happened in the society, the implication of many forces of civil society in upholding the Reich, that it wasn't just a matter of excluding a general or, you know, killing or executing someone, but rather a need for a broader transformation. So that I don't want to say anything more right now about that, but there are, I don't know what's going on with the lights. There's a live debate. There's a live debate going on now. I work with a scholar at LSE, Yavor Rangelov. We have a unit on securityandtransition.org. You can look, those of you on Wi-Fi can look it up, www.securityandtransition.org. And part of what we're looking at is what is the role of law in helping to buoy or reinforce human security, not state security, but human security. And this is, I think, more understood on this side of the ocean than it is in the U.S. And part of the question is, what didn't happen in Afghanistan? You know, to what extent can one attribute the rise of the Taliban and other forces, other private actors in other countries that are seen as delivering justice? You know, to what extent do we need to worry about accountability and justice in those periods of insecurity? And what didn't happen in Afghanistan that did happen at the end of World War II. Now again, this is greatly simplifying, right? Because we're talking about different contexts and different parts of the world and so on. But this issue of post-conflict has really informed the field of transitional justice, right? And if we look today at where the field is, if you go to a conference like International Studies Association or APSA, there are many panels on post-conflict transitional justice. Well, what does this mean? What area of law are we in, right? And I think that, you know, if we reflect back on the post-World War II period, we can see that that tension was already present, okay, between the existing understandings of use post-bellum, the norms that attend the end of war, the issues of restorative justice versus something more transformative, and that was what was present and what was really informing the trials. There are UN reports now on this question of the problem of the vacuum of accountability, and as I said, I've co-authored with Yavor Rangelov on the issue of post-conflict and in a number of settings in the contemporary period. Let's fast forward to another context, which is the pacted transitions, those that don't come out of conflict, velvet revolutions, pacted transitions, negotiated transitions. And you've already heard Justice Sachs' comments about South Africa, and there have been other references to Latin America earlier in the day. So what characterizes these transitions? And here you can see that generally the repression was not isolated to a small group, but rather a large parts of the population, deep divisions, and very often what we see, and I really think that this is critical to any understanding of some of these reconciliation processes and moves away from accountability, part of what undergirds this is the earlier momentum and need for a constitutional consensus, for some kind of, and you could call it mythic unity, but some kind of some attempt to unite divided groups, and that's really what's at stake. And you saw this in South Africa. And I think here, the whole commitment by the judiciary and the commitment to the constitutional process often is given lesser weight than the TRC. We tend to, often when you say transitional justice to someone, they'll think bing, 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 Nuremberg Trials, right? And the TRC, and maybe they'll add something, else, but that's really, these are the highlights. Well, that, what is the legitimacy of the state limiting its punishment processes in one case over another, or failing to give victims vindication? That question really was preceded by a constitutional commitment and a decision in the country to unify. And if you look at one of the leading cases that supports the TRC processes, and again, it's difficult even to comment on this with Justice Saxon, and if I make a mistake, please, the Asapo case talks about the importance of the Constitution, its epilogue, and how it's the Constitution that points us forward rather than backward, and this idea of a bridge. And so this is extremely important, and you can see that, and again, each of these contexts, I want to argue, has its own legitimation, okay? Its own legitimation driver or machinery, and where, you can ask yourself, where was the consent to amnesty given? Well, you have a constitutional process. I would say the same thing was true in Uruguay, where you had popular referenda, and repeated referenda, mass majorities, so not just one and not a thin majority as you had here earlier in the week, but repeated agreements to have this unity in the country. Chile as well had this kind of constitutional commitment. So not just backward-looking, but forward-looking constitutional processes that animate and support these alternative approaches to justice. Another example is Colombia today. Colombia has been brought up a number of times. They've just entrenched their peace accord in their constitution. And I think this is a critical aspect to an understanding that there is a commitment to, some approach to justice with the creative sentencing agreement that they've come to. I was in Colombia September 23rd, the week of the agreement, and it was a very heady moment. And I think it's really, if you think about a country where the entire population had to endure a conflict, it's the longest standing conflict in Latin America, half a century. There is tremendous fatigue and tremendous, hope for this moment. And this is reflected in this connection between the constitutional project and that of justice and accountability. So that brings us to the contemporary moment, and that's the global one. And again, many of you already are either actors or scholars in this moment. What highlights this moment? I would say we're beyond the transition. So in many cases, we are either proactive, it's ex ante, and you see the role of transitional justice institutions acting before there is political change. And I think an example, mentioning Colombia, was the role of the International Criminal Court with respect to Colombia. In some cases, we're beyond the transition and much later. So you could say in Latin America, an example of the institutions associated with the Latin American human rights, the Inter-American Commission, the Inter-American Court of Human Rights, reflecting back and reviewing some of the decisions that had been made during the period of political transition. So you have beyond the transition, okay, and this gets to some of the issues of temporality that have been raised in the prior panel, beyond the state. So that's another aspect of the globalization. Well, it's not just the state that are, not just state defendants and not just state victims and state, it's not just the relationship with the state when it comes to victims' action. You have private actors that have committed crimes, and this is recognized, and you have an interesting and important engagement between international institutions and domestic ones. So that's really the most salient aspect of the beyond the state are a whole bunch of other actors that are in the game. If you compare the 1980s and the kind of space that Argentina, Chile, Uruguay, South Africa had to make certain determinations, there was no ICC at the time. The Inter-American Court of Human Rights was not actively reviewing to the extent that they are today. The first case, Velázquez-Rodriguez, is in the mid-'80s. So you have a series of decisions. You have leaders. You have elites meeting in hearing rooms and political leaders running for office on particular campaigns, particular strategies and policymaking, and the entire thing is thought to be a domestic matter. Now, this may seem inconceivable today because we think of, not just international institutions. The UN is involved in transitional justice. There's a rapporteur. There's the Human Rights Council. There are regular reports on, and the rapporteur himself, Pablo de Grief, is from the region, from Latin America, and yet he is expounding on other parts of the world. You have a variety of courts that are engaged in this process. You have the European Court of Human Rights has also been involved, the International Court of Justice, Germany v. Italy, Bosnia v. Serbia. There are a great variety of judicial institutions that are themselves have to think about what is their relationship to the local and to the political. So there are a number of bands here. One is the relationship of the international to the local, which of course is very much a part of your studies. But I think the other that's already been raised today is the relationship of law and politics. And this is really, there are a lot of tensions here. There are many actors, and as I mentioned, since we're beyond the state, there are actors such as NGOs. There's the International Center for Transitional Justice that started in the South African movement, but now has become quite international. And they organize groups all over the world. So there are transnational victims groups and their representatives, and there are local victims groups and their representatives. You have groups organized according to identity politics. You have gender groups. You have indigenous groups. You have religious actors in transitional justice, and explicitly so. So, and it's interdisciplinary. I talk about law and politics, but there's also, of course, many questions, and many of you come from other disciplines, philosophy, psychology, trauma studies. It really has taken off. So how to think about these relationships is really what, in the last 5 minutes I want to talk about, and then have opportunity for questions from you. How should we think normatively about this relationship between the transnational actors in transitional justice and the local? Phil Clark raised this in light of Rwanda, right? And that's a famous example of the tensions between having an international criminal court, having genocide, clear violation of the Genocide Convention, and local decisions to have Gacaca, to adopt a more conciliatory or less explicitly Western legal approach. And that's, he's written on that, and that's an example. But how should we think more, more comprehensively about this engagement between the supranational and the supranational, or subnational and the supranational? Maybe let's throw out the word legitimacy. What is the legitimacy of these transnational actors in this process? Now, let's, I want to suggest that global transitional justice, let's look at the phenomena, okay? When is it more common that international institutions or transnational actors will become involved? When have we seen this? And I think that we can say that in general, it occurs when politics is stuck, when there's a paralysis locally. And here, the way the machine moves is generally we see victims groups that have been beating the drum often since the political transition. They may be unperceived from the outside, but it's only when they get the support or there's action by a higher in the sense of international or transnational institution. So we can see an example, for a recent example, the Habre case, involving the terrible crimes against humanity committed by him. And for decades, he outfoxed those who were pursuing him. Doesn't mean that the pursuit was just this last week ago when he was convicted. This is a long process, but it involved victims on the ground and their representatives. And Human Rights Watch played a very big role here. So you have non-state actors, NGOs that have an international presence, that have worked with victims groups, and then were able to take it to a court, another court outside the jurisdiction. Now, that's an example, and you know, we certainly can, and many of you may have already worked on this, can ascertain when is politics stuck. He was certainly protected by strong countries, unfortunately including the US, and there's a recent report by Human Rights Watch out today about the protection that Habre got, and we saw that as well at the end of World War II. There were many that were able to evade justice because they were made contributions to the atomic program and so on and so on. I mean, this often happens, and it's just an explanation for why a transitional justice often occurs decades after the transition. But so that's one example, I think, of a successful combination of the local, the non-state actor, and then, if you will, the addition of the universality principle or some kind of, you know, possible regional justice. A place where justice was stalled as well as Latin America, my home turf. You know, yes, we had junta trials in Argentina immediately after the change. Alfonsín ran on this idea, but shortly thereafter there was military resistance, and you have the collapse of that program. There was no clear end to the prosecutions, so the military resists. So, you know, if it had maybe stayed within the junta leadership, and there are many philosophers writing about this, including in the cabinet of Alfonsín, the late Carlos Nino, whose book Radical Evil on Trial I recommend to you. So stalled after that, and in country after country, decisions made that at the time they sought some more. In some places like Argentina, it was a hiatus, but in others they sought more conciliatory approaches. Well, not everyone was happy, and you have victims groups going to court. And that's an example where victims groups went to the InterAmerican Court of Human Rights and with their representatives. And these agreements in Latin America have become opened up, and they've produced a series of cases. Now here, I think it's could be productive to think about when would we think that the Inter-American Courts, judicial, if you will, interventionism is on solid ground. Is this always a good idea? We start seeing, you know, this language of the human rightsization of transitional justice. Every victim is owed their own personal truth, right? And not only their personal truth, but their personal justice. And by some accounts, in some readings of these opinions, it almost looks like victims have rights not just to report about their case and an investigation, which would be quite normal and associated with rule of law in most established democracies, but even to their own prosecution of the criminals involved in their case. Well, what about that? Okay, in the past, these were seen as political decisions involving a collective. Some victims might have gone along with it, and others not, right? And others not. And that's the, you know, if you think about Justice Sachs and then the Azapo case. Well, in Latin America, we're seeing a rich set of examples where the court has become, if you will, hyper-involved, the Inter-American Court of Human Rights in these cases. Now, you have another set of institutions are now involved in Latin America, and that's the Colombia case, the International Criminal Court. And I want to suggest that the Colombia case, as opposed to some of the Rwanda or Bashir, Darfur, Sudan, that Colombia seems a more productive example, if you will. I don't know if I love this term, but of constructive engagement. Constructive engagement has a bad genealogy, but Colombia shows how some engagement with the transnational helped to jumpstart events on the ground. The ICC had reviewed the case for admissibility. Crimes would have fallen within their jurisdiction, and indeed did. And then the country came up with a plan that involves prosecution, but creative sentencing. Prosecution of the most serious cases, those that fall under the Rome Statute. Well, this is their determination, and we will see if this goes forward. But it's an example of an engagement between a transnational actor and the local and other victims groups as well. So what are, just to end, I want to suggest what we might learn from this, maybe some normative considerations. On the one hand, we have a big push in this area for solving these problems with one-liners, with reductive, if you will, or bureaucratic approaches, let's say best practices, one size fits all. And this is, this is an answer that I've opposed since the very beginning. The introduction to my first book in 2000 was to resist the attempt to give, for Latin Americans to dictate to East Europeans what they should be doing with respect to truth commissions and so on. And it really is a bigger problem than just the answer. It's really seeing this area as a set of measures or tools. I hear the toolkit and what's in your toolkit. Well, that's really not the problem, right? The real problem is how do you reconcile transformation, right, with existing institutions, and how do you move forward, and what is the meaning of justice in such context? And so here we see that there is and what you have now that's blossomed out of this area, and I think it makes it even more complex, is the human rights revolution, or the accountability revolution. And that is that you have many more commitments, and in fact even duties, that pertain to individuals, to victims. You have the human rights courts that have come down and said that victims are owed an array of obligations, and you have the International Criminal Court and its related, if you will, an orbit, a normative orbit, and I think this really, means that it's that much more interesting for scholars, right? For those of you working on theses and thinking about this, but it's also more complicated. So one principle might be I would say a call for context, really, as I began, a call to take context into account. Could courts take more of the political context into account in their intervention, in their decisions when they're intervening? Could they look to whether there has been accountability, an attempt to wrestle with accountability on the ground? Could we think of accountability not as a binary, but in terms of a continuum? And there's some language now in the Inter-American Court of Human Rights that talks about partial compliance. Okay, maybe instead of thinking, saying there's just impunity and accountability, maybe we need to think in a more complex way about a range or a continuum of accountability. The other thing that I would say, and of course some statutes or treaties already think about the relationship of the local and the transnational with, thinking about margins of appreciation or subsidiarity, those of you who are from international law. We're not, creating out of whole cloth here. That question of the relationship of, for example, a faraway human rights court and the local, there's literature here and there is case law, and I think that's something that we need to look at. Complementarity has already been mentioned. Complementarity is an attempt. It's a principle that attempts to reconcile or wrestle with the relationship of the transnational and the local. And I think here, there's a lot of talk, and I think it's true that we don't know what complementarity means. Complementarity with an E, not like with an I, like how good anyone looks at any given moment, but complementarity with an E, gap filling, willing and able below, below in the local. Well, can we answer that question? Can we even begin to address what does willingness mean and what does capacity mean, ability, if we don't know what the project is, right? If there's no clear agreement on the project. And I think this is part of what I'm trying to convey here is I think we have to back up, right? On the one hand, there's the bureaucratic insistence at a time of global transitional justice with an insistence, just apply the toolbox and get on with it. But I think really the richer questions here are these questions of engaging with what does justice mean on the ground, how is it being thought about, the question of accountability, and it's always, and I think that courts will have to take into account the legitimacy of existing political agreements. A self-amnesty is not the same as an agreement along the lines of South Africa. And this was mentioned by Justice Sachs before, right? 2 days ago. We can't say that the Pinochet's amnesty for himself or the non-accountability of Velázquez Rodriguez is the same as what Colombia has come up with. So we need to I think in a richer way about the legitimacy of politics on the ground regarding transitional justice. You know, we are probably always in the state of relative legitimacy in evaluating these instances in terms of relative legitimacy of a variety of institutions. Nothing seems perfect, but I do think that, you know, really just to end, that that judicialization and the rise of judicialization here, one of the positives is that judiciaries can work case by case. They can bring a range of materials to bear on particular cases, and judges and lawyers know that we're always in the state of interpretation. The law doesn't work on its own, and interpretation in a number of different contexts where a different set of materials will be brought to bear with respect to that relationship of the local and the international. So let me end there, and hopefully we'll still have a chance for questions.
Thank you.